Good morning. I'm John Sims on the McGeorge faculty, and it's my pleasure this morning to introduce the speakers on the first panel, which deals with the emergence of international property law and the influences that are contributing to that have brought about some of the changes that John Sprankling describes in his book and that are propelling us into the future that Matthew described and tried to imagine. So we've got the treaties and customary international law, soft law influences of various sorts. I got to say that one thing I really loved about Matthew's remarks is canvassing the breadth of John's ambition. So I think this would be a great party icebreaker. Ask everybody, like, what was your favorite section of the book? What the favorite object? You know, we've got obviously the space adherence, and mine was icebergs. Who owns icebergs? That would be, of course, imagined, not yet fully realized as a source of fresh water. So think about it. If you had to pick one special section, which would it be?
That's a lot of pressure, John.
The first panel on these influences, our first speaker is Dolidze from Western Law School in Ontario, Canada. She's originally from the Republic of Georgia. She studied at Cornell. And her perspective really is mostly from the human rights point of view, and obviously very much informed by the dramatic transitions in ideas about property that took place in what had been the USSR as the system was completely transformed, and where property was and is right at the heart of the disputes about how the society is organized and how it will be organized. So she'll lead off, and then the second speaker is my distinguished colleague, Jarrod Wong, who you already know is the co-director of the Global Center. He studied at Cambridge, University of California, Berkeley, and also at Chicago, so that really covers the waterfront, I think. And his special focus in his scholarship is really more on the taking of property through expropriation, and then the processes, arbitration, and others that are available to try and protect investors. So those will give us two big chunks of dramatic areas of development and change with regard to property, and will launch us onto the day's program. So,
thank you. Anna, please.
First of all, let me thank the Pacific McGeorge Law School for having me here. I'm certainly honored by this invitation. At the same time, thank you to the Global Center specifically for convening this forum, and for John Sprankling for laboring over this great book and giving us some material for thought for during the future years. So my talk will be divided into two primary sections. First of all, I would like to do a brief overview of what I took out of the book primarily, and second, I would like to provide 3 arguments, 3 points in relation to why should we be what I would call cautiously optimistic in terms of affirming or advancing the international human right to property specifically. So in terms of the wealth and the breadth of John Sprankling's book, I think that he has done a Herculean job of taking international law and mapping property-related concepts across a wide variety of areas, including intellectual property law, including global commons, including bioengineering, and many other areas in which you usually don't really encounter in the same manuscript, in the same textbook. So the book argues that although we traditionally presume that property is mainly regulated under municipal law, international property law permeates municipal law and governs and influences lawmaking in relation to property in municipal law. It argues at the same time that international property laws should be conceptualized as a distinct category, and that it's obvious if you peruse the book and read the book that indeed there's so many rules in relation to property at the international level that it is the time that somebody, an intellectual, took them together and organized them in a clear and a coherent way, and that's what John Sprankling has done. According to John Sprankling, there are implications and benefits of creating a specific category of international property law. And there are two kinds of implications. One is jurisprudential, I would call conceptual, and the other one is practical. In terms of jurisprudential implications, that first benefit is harmonization across fields, and I find this highly beneficial. I agree with this, because we have same concepts which are used across a variety of fields. One example that John has is security. So you have a wide variety of areas where securities are used, as property as security is used. So it's great to harmonize them across these areas. And echoing a point made here, I think that would be very highly beneficial for international dispute resolution and for inserting legal more certainty in international dispute resolution. In terms of another jurisprudential implication or benefit is the fact that if indeed John is right, and that's how we understand law, law derives its authority from certainty, clarity, and order. Creating a separate category of international property law will improve legitimacy of law by improving certainty and clarity. On the side of practical implications that were already mentioned here, these are clarifying and making the rights of international organizations more certain, because these organizations will know what to expect in terms of property rights in various fields of international law, at the same time clarifying and making certain the rights of non-state actors who already have rights. Nevertheless, we might still don't know which rights and what to the extent of these rights across various areas. I really enjoyed also reading his forecast in terms of what will happen with international property law, because globalization is on the rise. Human relationships and relationships across capital, across various countries will intensify. Therefore, our conversation will more intensely focus on the questions of property and exchange of capital across borders. This topic will be even more pertinent in the future than it is now. But I did notice that Professor Sprankling is quite cautious in relation to the enhancement and advancement of property rights under international law. Although his take is normative, I think Professor Sprankling does endorse the development of human right to property and the benefits, the normative benefits that flow from it for individuals and their protection of their human rights. He's cautious in his endorsement, and he does provide a couple of statements in relation to which, in relation to circumstances where public policy interest and public interest should be balanced against robust or absolute endorsement of property rights. In terms of my impressions of what kind of contribution the book provides to scholarship on property and international property, it's interesting that actually I found the book in the domestic law section in my own university library. So I was looking. I took the number, the stack number, and went looking for it. Intuitively, I thought it's going to be. I know the international section very well. It's going to be in the international section. No, it's not there. It's in the domestic law section. Alongside the other books, Global Issues of Property, Trust, Servitudes, Covenants. And I think the reason here is that, and actually gives us a lot to talk about in terms of the kind of contribution the book is doing to scholarship. The reason here being is that the librarian or the archivist who got the book saw the title property in it and thought, oh, property can't be international, it's in the domestic section. So I do think that the book is providing a great contribution. It's opening up a new research agenda for those of us interested in the issue of internationalization at large. And that's where my research interest lies. So property is one area where internationalization has taken place. So international law, unbeknownst to us, or while we were busy with other things, has been drawing on various property law concepts which emanate and come from domestic law, Roman law, or English common law, but domestic law, and has been developing internationally. And now we kind of we face it in the mirror and we realize that this body of law is there. Actually, I do think that the whole theory of internationalization has a great potential in terms of making us think in terms of what are the specific systems, cultures of law from which international law borrows legal institutions. those of us that study international law, we know that general principles of international, for instance, are those principles that are endorsed by civilized nations, but currently it's a universal, some kind of universal consensus that is deduced by the International Court of Justice. We also know that international draws on decisions of courts, judicial bodies, or draws on writings of particular scholars, that these are sources of international law. But the specific processes and conditions that lead to internationalization in various fields have not yet been studied, have not yet been theorized systematically, and I think what Professor Sprankling has done is open up a door in terms of charting a new research agenda for many of the junior scholars that are interested in the area at large. I myself have discerned a couple of areas where internationalization has happened, like it has happened in property law. It has happened with amicus curiae interventions from English law, international law. It has happened with the OECD Bribery Convention, which clearly and significantly drew on the Foreign Corrupt Practices Act of the United States. It has happened with the concept of trust, which served as the foundation of the League of Nations mandate system. So I hope that the theory of internationalization will strongly build on Professor Sprankling's work, strong and serious work, and pioneering work on internationalization. Second, however, even if his normative point in terms of creating a separate category of international law will not catch up, will not be implemented right away, or will, like Thomas Kuhn's work, will encounter significant resistance, at least what he has done with his work for a relatively junior scholar like me is help us eliminate the blind spots that we might have, because we don't know that there are all, for instance, in terms of one of my favorite points in this book is a realization there are all these registries that are kept in various international law fields of which I wasn't aware of. So, for instance, if one is teaching global commons and is teaching Arctic and rights and obligations in relation to Arctic, Professor Sprankling's book allows us to look at a section on global commons and immediately compare various norms and regulations in all other areas of global commons. And lastly, is the historical dimension of the book. I really appreciated the background which he has given to almost any legal property law concept that is in the book. It has a Roman law history, it has a common law history, and I think for anybody who's teaching property law, this is very helpful. It also eliminates the myth that there's a great difference between civil law and common law, and shows the overlap and the mutual borrowing of the systems. Now, in terms of my interventions, then the three cautionary notes in terms of us endorsing international human right to property, or just as a potential to avoid what often happens in the human rights field, what is called a human rights triumphalism. So there are three kinds of interventions, or three kinds of notes that I would like to make in relation to specifically how international human right to property was formulated. So first of all, let us remember that human rights language at large is hegemonic. And when I mean hegemonic, I actually mean that it's emotionally very powerful and influential. It's at the same time very pervasive, and it's a governance instrument. And that has a particular implications, especially when human rights are used as indicators to achieve particular social economic goals. So that's argument number one, they're hegemonic. Argument two, a human right to property is one of many ways of conceptualizing property. Some of the authors, and Duguy in particular was mentioned here today. So perhaps when we use automatically, when we refer to endorsement of the human right property, what we do at the same time is forget or overshadow all other conceptions of property that are there, including property as a social function. And lastly, for international formulation of a human right to property is a result of a particular historic moment, especially in Europe, and I would like to pay attention to that. So in terms of the fact that human rights to property is hegemonic, it's many scholars who have written about human rights in literature and human rights narratives have emphasized how human rights, because it's an emotional language, it's a highly powerful language, leads to individuals to formulate and construct their narratives in particular ways. So there's work by Clifford Bob, interestingly, it's called Merchants of Morality. There is work by Sidney Smith and Key Schaffer, Human Rights and Narrative Lives, The Ethics of Recognition, which shows how attention that comes from public to human rights claims makes people construct their grievances that could be constructed in a wide variety of ways as human rights grievances. As somebody who used to chair a large legal rights center, I can tell you from my personal experience how if you have a person with a grievance that comes in front of you for whom you would like to find a legal remedy, let's say, from my own example, it would be a woman whose child has died as a result of disproportionate use of force by the police. The easiest way, and this is the most convenient way if you want to be beneficial for the person you represent, is to formulate it as a human rights claim. Right to life, violation of the right to life, violation of the right to torture, and so on and so forth. Well, there isn't anything detrimental in this unless we think that because human rights language is so powerful and so pervasive, by defaulting into formulating human grievances as human rights claims, we are forgetting about all other ways through which we can formulate the same kind of grievances. And the biggest, probably the first thing that comes to my mind is the language of social justice. The other example of that is how human rights as a field has been pervasive because it's so influential. So for instance, most recently we saw that in front of the International Tribunal for the Law of the Sea, which adjudicates law of the sea disputes, where in relation to the Arctic Sunrise case, where the Russian government has arrested a Greenpeace activists, the interveners have tried to import human rights conventions and ask the tribunal, law of the sea tribunal, to adjudicate on human rights issues and issues of civil and political rights. We can see this in refugee law scholarship, which was originally refugee law was subject to a completely different logic, not logic of individual human rights. But lately, after the 90s, with the breakdown of the Soviet Union and the fall of the Berlin Wall, human rights concerns and refugee rights have been merged, and some would say have even taken over the logic of refugee law and policies of refugee return. Finally, in terms of I would like to give you just two specific cases, examples where issues that otherwise would be specifically formulated as issues of social economic policies have been formulated as human rights concerns. And we can see that Professor Sprankling has these examples from European Court of Human Rights jurisprudence, and we can see that all the time from the European Court of Human Rights. One case, for instance, is Back against Finland, where Finland, as a result of financial crisis in the 90s, had entered legislation which restructured debt because it was prompted to do so to respond to the financial crisis of the day. A person, Mr. Beck, who had lost out on the income because he had served as a guarantor on the loan, and as a result of this public policy intervention, restructuring of the debt, he had lost some of the income that he was supposed to get. He formulated his claim as a grievance of the right to property, and the case went all the way up to the European Court of Human Rights. Another case, the same English pensioners who were arguing that the fact that the British government was not adjusting their pensions in relation to the inflation of the British pound was a violation of their right to property. Luckily, in both of these cases, the European Court said, well, these are matters of domestic public policy to be adjudicated by domestic policymakers. But these are just examples of how concerns which are subject to policy concerns within municipalities are currently being formulated or being incentivized to be formulated as human rights concerns. Now, why is this? What is the implication of this? The implication of this could be the fact that many issues which should be domestically dealt with social economic policy instruments are hard to be dealt as such because they encounter the all-pervasive, emotionally powerful, and at the same time, legally powerful individual right to property. And I give you a specific example from my own practice. I served as a counsel in the European Court of Human Rights case, Dolidze in Georgia. You might be aware that after the breakdown of the Soviet Union, many countries of the Soviet Union immediately embarked upon property restitution laws. Baltics are one of the examples. Georgia didn't. It was embroiled in 3 wars, so nobody had time for property restitution. At the same time, there were these individuals, our own clients, 2 really respectable, nice gentlemen whose property had been appropriated in the beginning of 20th century. So we filed a claim under the European Convention of Human Rights. We actually won the case, and on the stance, the court mandated the Georgian government in 2010 to adopt measures and to put the measures in place to make profit for them, to create remedies for them to return the property that had been confiscated by the Soviets. At the same time, none of the Georgian governments had embarked upon this measure. Nor the previous government, nor the government that has come to power under 2012. Why? Because from the policy perspective, the governments are caught under a variety of conflicting values. The values of property restitution on the one hand, on the other hand, the vast majority of people who would be completely antagonized by this measure of returning wealth to the people that were originally wealthy. On the other hand, the questions of distributional concerns are on the place. So no government so far has taken up the risk of actually following the mandate, the obligatory mandate from the European Court of Human Rights and putting the measure in place. Okay, last 2 points, and I'll be relatively brief on this. Human rights historically is a a right to property is a highly contested concept. This is how I start my property course, to make it a little more interesting and prepare students for the study of rule against perpetuities. It's highly contested. It's politically very intense. It's going to be very interesting. Yeah, so I don't know, but it's true. We those of us that study property, it's true. We know there are a variety of conceptions of property. There were some of them were mentioned. As a student of Gregory Alexander, I cannot not mention the social obligation norm of property, the fact that property and community and citizenship obligations historically have always been intertwined, and some of the examples that are out there. So when we speak of human right to property, my contention is that let us think that it's the individualistic, legalistic conception of property as a legal entitlement is one of a number of ideas of what property is, of what the role of property is in society. And my third and last point is in relation to international human right to property has been a product of particular circumstances in Europe at the end of the World War. So usually the traditional narrative is that human right to property has been formulated as a response to the end of Nazism in Germany and the World War II, at the same time to the potential rise of communism on the other side. But we shall not forget that, first of all, there were points actually in relation to the formulation of human rights where the Soviet Union and the British, for instance, agreed. There was a consensus that they did not want to give teeth to the human rights that were drafted at the same time. There was a consensus that human rights had to be adopted, the language of it, but not with too many actual implications or potential for implementation. However, on the other hand, there were also harsh debates specifically in relation to right to property in the West. So leaving German fascism or the potential rise of communism, and specifically the first right formulated as a legal right to property was advanced in the European Convention of Human Rights in 1952, and I find that moment is very interesting. It's really not easy to find a narrative of what happened there, but the 2 dates we have to keep in mind. The original European Convention of Human Rights, which endorses an individual right to property, albeit restricted, was adopted. The convention was adopted in 1950, but in 1950, the drafters of the convention could not agree on the formulation of the right to property. It only happened in 1952 separately as a separate protocol. But so what happened in these 2 years, from 1950 to 1952, that led suddenly the drafting committee changed their mind and endorsed the right to property? Well, what happened is a change of government in the UK. So we have to remember in 1945, in UK, it was the Labour government that was in force. That's when the European Convention started to be drafted. And at the time, Labour government was running on the agenda of nationalization. From 1945 to 1950, the Labour government of UK conducted a number of massive nationalization. They nationalized National Bank of England, railway, coal and steel industries. lots of things that currently would not stand up to international scrutiny under the International Human Right to Property. So when the Labour government was in force in 1950, they did not want international human right to meddle in their domestic agendas of reorganizing social and economic sphere in the UK as a result of Second World War. But what happened in 1951? Change of government, and Winston Churchill comes back to power. Conservatives were against nationalization. They were the ones that were strongly against the Soviet Union, the potential spread of socialism towards the West, and therefore they did endorse the right to property in 1952 of the demonstrations. So just to end and to join Professor Sprankling in the cautious endorsement of the human right to property, I would like us to think that when we do endorse human right to property, there are some things that we are winning in terms of the certain guarantees for individuals, but there are also some things that we are losing. And what we are losing is the bank of ideas that existed at the time when international human rights to property has emerged. And it is possible for us to think that perhaps when dealing with the dilemmas of 21st century, and when we're interpreting the international human rights to property, we might want to go back to this bank of ideas in terms of searching for the better social and economic solutions to the current problems. Thank you.
So let me thank you all for coming again, and I want to extend special thanks to our out-of-town panelists, although not for entirely honorable reasons. Let me explain. John's book pretty much epitomizes the man, right? It's relentlessly rigorous, right? So I approach my task today with no small measure of trepidation. I'm used to conferences where each person just comments on one person's work, right? And so in that situation, I am mischaracterizing my poor victim's work alone, and then bear that responsibility alone. But today I share the lovely responsibility of mangling his book with everybody else here. And I think optimistically that surely somebody else will destroy his book too in that process, not intentionally. So with that heartwarming caveat of sorts, let me turn to the talk. I mean, what's remarkable about the book is that it posits this singular theory of the law, international law of property. But then it does so, right, by looking at the operation of international law in these apparent silos, right? Investment law in the human rights area, in IP, in space, and then it brings it all together under one framework, right? And what we see at the end of the enterprise is that there are all these overlapping claims at the end of the day that we have to figure out how to resolve, right? And that we cannot be thinking about international property law as applicable to only one particular regime, right? And so, in parallel, what this panel thought we would do is that Anna would do a broad survey and then touch on the parts which implicate human rights law, which she has just done. And I'm going to take the silo approach and look specifically at the operation of the international law of property in the foreign investment context. John, in this area, substantiates his theory by drawing parallels between the domestic and the international regime. And in particular, the centrality of the right to use property is evident in both laws. The thought process is by showing that they share the same core features, then we can legitimize the international law of property. Now, as John very ably notes, right, the right to use has been a very central feature of domestic property legal systems, going all the way back to the Roman law system. The Justinian Digest defines usufruct as the right to use and enjoy property. The French Civil Code defines ownership to include the right to enjoy things in the most absolute manner. And the German laws essentially do the same thing. The common law system, right, has very much the same definitions as well if we look, for example, to the Blackstone commentaries. And in fact, there are state constitutions that specifically define, right, the right to property as including the right to use. So see, for example, the constitutions of Argentina, Ethiopia, and Russia. Although in the latter case, they've been so enthusiastic that they have applied this extraterritorially as well. So moving from the domestic system to the international system, do we see this right to use? Well, yes. In expropriation law, which essentially is the permanent taking of property, it's very clear, and it's a rule of customary international law, that expropriation is not permitted without compensation. And right, the most intrusive manifestation of expropriation is to physically seize the property or to otherwise force a transfer of that title. So see, for example, the nationalizations of the oil industries in Mexico and in Venezuela. But if we're just talking about outright expropriation, it's hard to tell whether the right to property in fact includes the right to use, right? If the entire property is seized, how do we know that we're not just talking about the title as opposed to the right to use? Well, expropriation has been defined under international investment law to include not just direct expropriation, but indirect expropriation or creeping expropriation. And essentially, we find indirect expropriation to occur when there is substantial interference with property rights to such an extent that they are rendered useless, even if the title remains formally with the owner. And so an example would be the Metalclad case, where a US company had the contractual right to develop and operate these hazardous waste landfills. And the local authority ended up refusing to grant the necessary permits for that operation. Right? The title had not transferred and remained with the US company. Right? Nonetheless, the tribunal held that this was an expropriation, an indirect expropriation, because even though the title, right, remained with the US company, there was not much it could do if it wasn't, in fact, permitted to operate the waste landfills. Another example might be the revocation of an economic free zone status that was formally granted. Right? And again, in those cases, there is no transfer of title. Yet we would find indirect expropriation to occur. And more importantly, we equate that with expropriation, i.e. we would treat that as if it were the taking of property. Even though the title hasn't been transferred, what has changed is that, right, the claimant no longer has the right to use. And so we see this same valuation of the right to use in international law. Indeed, this right with regard to expropriation and indirect expropriation are formally set out in many, if not all, bilateral and multilateral investment treaties. So, for example, the French model treaty provides that neither contracting party shall take any measures of expropriation or nationalizations or any other measure having the effect of dispossession, direct or indirect, of nationals or companies of the other contracting party. Similarly, other standards of investment protection that we find in these investment treaties are very property-centric. Including, for example, right, the full protection and security obligation for foreign investments, which are found in most investment treaties. That standard safeguards, right, the physical security of foreign-owned assets. And it not only obliges, right, a host government to refrain, right, from physically damaging the particular investment, it requires them reasonably to take measures to prevent third parties, a marauding crowd, for example, from damaging that particular investment. Right? Another standard that is provided under most investment treaties is that of fair and equitable treatment, which must be accorded by the host state to investments under these treaties. It's an extremely amorphous standard, but essentially it's been read to prohibit the contravention of basic expectations of the investors, and the need for the host government to provide for consistent and transparent administrative regulation. It has been, however, applied, right, in multiple cases to what essentially has been an expropriation of property. So again, for example, in the metal-clad case, right, which involved the indirect expropriation, the tribunal found that it was a violation, right, of the fair and equitable treatment standard there, not to have provided clear guidance with regard to the local municipal permit system. So, I mean, that in a nutshell, right, is kind of the application of international law in that particular area. And it is, as I've noted, customary international law, so not much disputed. When we step back and look to see, right, the broader picture governing the state of affairs, I mean, what's interesting is the parallels, right, between the two systems, right? The paradigm change here, right, in the domestic system, right, is the historic transition from common ownership to private ownership. And once we recognize that, then we recognize the right to use. In the international context, that same transition has occurred, but it's been complicated by state sovereignty issues, right? And so, indeed, for the longest time, international law did not even recognize the private individual as a subject, right? Only states could be a subject under international law. What has that meant for investment? Well, for the longest time, if an investor had, for example, her investment seized and expropriated and wanted a remedy against the government, they had two choices. They could basically file suit, right, in the host state's courts, which didn't always guarantee a remedy. Or they could proceed under diplomatic protection, which was to go back, right, to their own state government and have that government plead its case. Not a very useful exercise because it was entirely discretionary. I mean, what has changed, right, in the international investment field is the introduction of the investor-state dispute resolution provision in bilateral and multilateral investment treaties. And John refers to this phenomenon, but being biased, I would have preferred him to even dedicate more space because I do think it represents a true change in the way we conceive of property in international investment law and ultimately international law. And what happened with the introduction of these investor-state dispute resolution provisions in the first modern bilateral investment treaties is that for the first time, the investor could directly initiate a claim, right, against the host government without having to depend, right, on its government to do so. And that changed the story of investment law. It basically created the law that I'm now privileged to teach, right? And that's because it anchors it, right, in this idea of private ownership. Now that the individual can bring a right against the host state government, right, the idea of this international right to property has finally crystallized in this particular context. And I think that is the paradigm change that allows us, right, to talk more concretely about the international law of property more generally. So with that, I think I'll stop here and we can have a discussion about the interaction between the two issues.
Who wants to start? Any questions? Well, I guess I would, one common element maybe in the two seemingly disparate topics you addressed, I guess my immediate reaction is why do people frame claims as human rights claims is because if you're in Europe, you can get to the European Court of Human Rights rather than being stuck with some national government that is not going to necessarily be very attentive to your claims. And Jarrod, you're describing something similar, that basically the solution ultimately is finding some other forum that you can go to. You don't have to depend on somebody else to bring the case. You don't have to count on the home state courts to give you justice. So really, so in each case, what the property that's being recognized ultimately is achieved just by kind of shifting who it is that's going to make the decision about whether you have a valid claim.
And that's fine when you're proceeding in either forum exclusively, right? But what happens when each regime butts up against the other, which has happened with investment law and human rights, right? Because actions taken by investors may implicate human rights, the human rights of the population of the host government. And yet the host government...
Sure, like in a mining or other extractive industries situation.
So
that would be the classic.
Right, and so, in the metalclad case, for example, right, the local population did not want the hazardous waste there. And yet the federal government's hands are tied because having entered into NAFTA in this particular case, right, its obligations under NAFTA are to ensure, right, the fair and equitable treatment of that particular investment. There is no space, in other words, within the structure of these investment treaties to accommodate human rights. And so what would happen is that the government will end up being liable on both fronts, right? And the question is whether this is a good idea or whether we should be stepping back, looking at this from a broader perspective and thinking we should be trying to find a system, I guess, that accommodates multiple stakeholders.
I don't think so.
Yes, so I guess one of the implications of this process of internationalization is that the body that's going to adjudicate the claims is not going to be either your court or your administrative body, but it's going to be a collection of experts from various countries that sits in Strasbourg as opposed to Tbilisi or Chisinau or anywhere else. And there are problems from the literature of international dispute resolution. We know that there are problems with this. There are concerns with democratic legitimacy from scholars. We know that there is a democratic deficit in that sense. They're not as accountable and responsible to the domestic populace as a local government, which can be thrown out at the next election, like the Labour government in Britain was in 1951. That's one. The second one is the issue of culture. And looking at the scholarship on culture of international institutions, they do draw on some concepts and ideas more than others. I can tell, this is from my own scholarship as well. The way these institutions are constructed and designed from the beginning influences how they borrow from various cultures and understandings. And to be fair, there are mechanisms, amicus curiae is one of them, which have been developed to supplement this idea that individuals, the judges that come from civilian background or common law background, or from different cultures, from first world industrialized liberal democracies, might not be aware of the kind of challenges that a non-first world, non-industrialized illiberal country will face, right? So there are mechanisms to compensate and help to support the system that way. But there have been criticisms waged against this kind of internationalization. And you're right, Sidney Terror, who's a sociologist, he calls it that international institutions serve as coral reefs. I like this metaphor. It transforms us to the law of the sea. Coral reefs that attract all actors, but they go to Strasbourg, they go to Hamburg, as opposed to contest these claims domestically in their capitals in front of their municipalities, and so there are implications of this.
So what you say is about the questions about having such a supranational decision maker, that's true, but it's also true for all other areas of human rights. I mean, would you say that international mechanisms are either less justified in deciding property matters or less capable of deciding property matters, or maybe just less experienced in it than compared to free expression or due process or criminal protections or the like?
No, I would rather say that human right to property is more contested currently than the right to life, the prohibition of torture, prohibition of slavery. There is, even with countries who engage in these acts routinely, there is a normative consensus that these are things that we are supposed to endorse and uphold. But right to property, even though criticisms that I mentioned have been voiced in relation to the adjudication in these areas as well. But right to property is particularly controversial because it specifically deals with socioeconomic reforms that developing countries have to engage with. It's an area where they're even more contested than any other civil and political rights that you can think of. Just because with economic development, industrialization, routinely these countries have to step on the feet of people who own property. Right. So a big issue, for instance, is the landless rights movement in India. So on the one hand, the way I've heard about this, I'm not an India expert, the way I've heard about this, there are absentee landlords, people who own vast amounts of land, but they're absentee landlords. The land is not used for economic agricultural purposes. And on the other hand, there are millions of people who are starving, have no access to land, and all they would demand is mostly a right to use. So some way to use the land agriculturally to produce the crops that feed themselves. So
this land is unused?
Absentee landlords, yes. They're
well, but I mean, like a lot of the property law goes back to the absentee landlords, but there are people that are working the land that are being exploited. But
no, in some cases, as we know, land is a great method and a very stable method of investment. So in many cases, you have owners of land who will not invest in working on the land because it will appreciate in value anyways. This is my understanding of it. So you have people who demand access to land, but on the other hand, so India is a developing country, is on its way to modernization, industrialization. So on the one hand, they have to do with this vast people of poor people and provide some kind of access to the property. On the other hand, you have this right, international human right to property, which is very strong, very influential. And the moment they embark on it, somehow they will be criticized, whether they will do it in a restrictive manner or whether they'll do it in an expensive manner. So, back to your question, right to property is more controversial and more contested than any of the other civil and political rights.
Although I think there's more to that than just complexity of the law itself. Right, I think the basic question here is who has the authority to pronounce on this particular right? So let's take your example, and now let's have the land, right, that could be growing all of these crops to feed them be owned by a foreigner, right? And so now it becomes a foreign investment, right? And so the question is, okay, who gets to decide that the human rights of the population that needs the land to be used to grow crops, right, displaces the investment rights of this particular foreign investor. Even if we didn't have a foreign investor, the country, whichever country we're talking about, would say that it has basically the right to control the use of its land, and having basically transferred the title to the land to a particular individual, that the individual has that right under state law, right, to decide as he likes, and therefore no international tribunal should have a say in that. And so, what the problem here appears to be one of where do we locate, an ultimate authority, and I think the nature of international law makes that very difficult to find, right, an omniscient tribunal that can take account of and have an authoritative voice in resolving all these various intersecting problems.
Yeah, Nicole.
We've been talking a lot about international and regional enforcement mechanisms, and there's been a focus on the European Court. And I just wondered if you could talk about the possible development of this right in the inter-American system, or as laid out in the Universal Declaration, a more broader or universal development of it, and whether or not there are similar suits being filed in the other regional systems, and also whether or not any of those are competing, if we are possibly adjudicating or defining the right to property in the inter-American system in a different way than we are in Strasbourg or at the African Court of Human and People's Rights or something like that.
Okay. I would have to peek into John's book to respond to your question. But shortly, I think it's highly uncontested that the human right to property is a dominant paradigm. Questioned, resisted to, but it is, the fact that it's being resisted to and criticized, it means it's very powerful, right? So if it wasn't powerful and important, people wouldn't talk about it. Currently, an individualistic right to property is something that's dominant, mainstream, being litigated, criticized, nevertheless vastly endorsed and supported globally. So I'll stop here.
Jarrod, did you want to add anything on that? Or?
No.
Okay, Tom.
Yeah, I just actually, maybe I can respond to it because that's precisely what I'm talking about at 11 o'clock. So maybe just apply the state for another 20 more minutes. Yeah, I won't say anything else.
Well, we've seen the pathetic methods we can, to sell the books and now to sell the talk. John, frankly.
I just wanted to point out that was quite right, pointing out that categorizing property as a human right is extraordinarily messy. It is the only right in the Universal Declaration which didn't make its way to the Covenant, substantive right, because of all the infighting. And I think someone has said that the right to property is the most limited and qualified right of any of the so-called human rights, and maybe it's not properly classified as such, right? The socioeconomic rights are extraordinarily weak. It's not like the right to be free from torture or something like that, which as you suggest is universally recognized. So the right to property, it's, we like to say all human rights are equal, but I'm not really sure that's true. And should property be human right? It's a huge issue, and I really like the interplay that you had together on the issue of foreign investment in particular, because as you know, one of the big issues is foreign investment, particularly in Africa, where entities from other countries are buying up huge tracts of farmland, displacing subsistence traditional farmers, and the huge conflict between a strict, internationally recognized right to property, which includes right to transfer, and the needs of subsistence of farmers, particularly in Africa and Asia, and their own human rights to sustenance. So that's why I think Matthew is quite right in the opener, saying, it's messy, and there's a lot of work to be done, and it's going to be very controversial. So I'm delighted by everything you said, because I agree with everything.
Yes, Frank.
One other, you took word out of my mouth in response to the question. It seems much more contested, but it seems to me one of the problems that makes it messy is the attempt, maybe that's stage 2 of the book, human right to property, how much property and how did you acquire it? So you looked at the flip side, the negative implications on social policy of the inability to redistribute property, nationalize property, or so on. But there are the two other sides of the equation, which to me, if you talk about human rights, are critical. How much? I could certainly see a situation where if somebody is completely stripped, and I mean literally stripped of all property, that so impacts your ability to even continue to live and live at any level of dignity, that one would say, well, that would be a human right that would be universally recognized, answering Jarrod's question about who decides. On the other hand, when I see great sources of wealth being heavily taxed, being redistributed, I guess I'm enough of a leftist to sit there and say, I may not agree with that, I may disagree, it may be a variety of policy issues, but I'm not sure I see a human right policy there. I don't have that great sympathy when great wealth is broken up, as it's a terrible tragedy of human rights. It also may depend on how it was acquired, which I guess gets into all the sort of both cultural and intellectual property rights. But going back to feudalism, the fact that the king, he fought for the king centuries ago, and therefore I got Downton Abbey, and that's why. Again, I'm not all that sympathetic to. So that's why it becomes contested. I think you pick up one, the sort of flip side usage, but you also have to think about the amount of and the acquisition of as part of the whole thing. It makes it extremely messy.
Did you have any comments? I mean, you've provoked me, Frank. I was tempted to say when John was saying, property is being more recognized as a right, but it's subordinated, it's not given its due. My reaction was to say, well, yeah, in the old days that the property people are so enthusiastic about, property was completely dominant and was every other right was subordinated to property rights, like those, poor Irish people that I'm descended from, who were completely oppressed and exploited by the absentee landlords in England, and that was, that was the way the whole society was organized, was to serve property, not other human rights. But I wouldn't have said that except for Frank. So. Yeah, Coach Hill.
Listening to this conversation, I think John is right. This subject is contentious, and maybe it shouldn't. If we were to root it in the basis of humanity, I think there's a lot of job to be done. There's a lot of work to be done in international law period, in terms of including all the regimes, all the cultures, a lot of experience across the world that doesn't count for much in the way in which the system is set up today. And if we start to include, we begin to see the patterns, parallel patterns, that are going back to Aquinas, go back to the Greeks, and we will find a very common theme that runs through history. In spite of feudalism, in spite of tyranny, and I think there is, it seems to be natural that there is a right to property, and then of course there are collectivities, there are clans, there are tribes where the right to include and the right to exclude are bundled. And so, I see this question, if you want to put it against the context of the European Convention on Human Rights, to me it's limiting. If you want to put it broadly, it is easier to ground it in evolutionary biology.
Comments on that? Or?
Yes, I would agree with you. So I prefer teaching property theory than property law, because property theory is this area of freedom, while property law is area of restriction for me as a scholar, right? So because with property theory, for instance, I would sign on to either John Locke's writings about property, that you mix your labor as an academic, so you mix your thinking with something and it's yours, right? That makes sense. And even thinking in terms of economic development, you probably need to reward this kind of thinking. You need to incentivize people to work more, and by rewarding them with the output of their labor, for instance. The same for Hegel, like property and the way property, owning a house and having a right housing is intertwined with your ability to develop your person, defending against the state. So that's property theory. On the other hand, in the realm of law, so with legalization, what has happened is that there were so many concepts that were left out in order to focus on one specific legally enforceable formulation, right? So that's what happens with legalization at all. However, it's so powerful, as we talked about, because then it drives the whole industry of lawyers, academics, claimants that grasp onto this legal formulation. So yeah, there this sides to property, both the theoretical one and the legal one.
You can have the last word if you want, Jarrod.
I like Kojo's suggestion that maybe we shouldn't assume that we have to work within the system. But when I try and think about an alternative, I'm stumped, right? I mean, we as human beings, we need to live somewhere. We are tied to the earth, and so is there really another feasible framework?
So we're going to